appeal in the matter of Mur Shipping BV and RTI Ltd.
May it please the Court. On this Section 69 Arbitration Act appeal, brought with the permission of Mr Justice Jacobs, I appear, together with my learned junior Mr Shirley, on behalf of the Appellant RTI Ltd, a Jersey company, instructed by Claimant, and my learned friend Mr Eaton, King's Counsel, leading Mr Woolnough, instructed by Rosalind King LLP, appear on behalf of Mur Shipping BV, a Netherlands company. My Lords, with your permission, I would like to make 10 points by way of introductory remark, and then turn to consideration of issues in the case. The issues I propose to address in the following order. Firstly, I would wish to summarise the key findings in the award. Secondly, an analysis of the judgment of Mr Justice Jacobs. Thirdly, principles of construction that apply to ascertaining the meaning of reasonable endeavours in the force majeure clause. Fourthly, the Bullman and Vancouver strikes cases, which the judge found so persuasive. Fifthly, whether mitigation provides an apposite analogy when construing the reasonable endeavours obligation in the force majeure clause. Sixthly, the Suez cases, which are frustration cases, which we say are illustrative and instructive. Seventh matter to address are policy considerations. And the eighth and final matter is why the appeal should be allowed. So, my Lords, if I may then begin with my 10 short points by way of introduction. First point, this case is all about the true construction of the force majeure clause in clause 36 of the Contract of Affreightment, or COA, and the meaning of reasonable endeavours in clause 36.3d. Now, the text of clause 36.3 and indeed the whole of clause 36 is to be found in paragraph 19 of the judgment, which is in your core bundle at tab 5, starting at page 62. Now, clause 36.3d, which is the provision with which we are particularly concerned, was a specially negotiated provision which was introduced into the recap. And it provides that a force majeure event is one which cannot be overcome by reasonable endeavours from the party affected. Now, my second introductory point is this. An experienced LMAA tribunal comprising Mr Jeremy Rusal, KC, Mr Mark Hampshire and Miss Sarah Kay, found as a matter of fact that the force majeure event in this case was a temporary delay in transmission of US dollars to Mur through US banking channels, but that any temporary delay in receiving payment in the contractual currency of US dollars could have been overcome with no detriment to Mur by RTI transmitting euros to Mur's bank in the Netherlands, which would then be converted into US dollars as soon as the euros were received, with RTI bearing any additional costs and exchange rate losses in converting euros to dollars, as RTI had previously agreed. That's a summary of what is in paragraph 50 of the award, and we'll go to that in more detail in a moment. My third introductory point is that based upon those factual findings, the tribunal concluded on the facts, that's their award, paragraph 51, that the force majeure event could be overcome by reasonable endeavours from the party affected.
Who's the party affected?
The party affected is Mur, in the sense that it is not able to load or discharge, as the judge has found, until it is paid. And therefore, it is the party affected in that sense. It could refer to the fact of the temporary restriction affecting RTI. But if RTI is to be regarded as the party affected, then equally the finding of fact, which is that they did what they could to overcome the problem, would be satisfied. But everybody's been working on the assumption that the party affected is Mur for present purposes.
So if that's the case, then all they have to do in the exercise of reasonable endeavours is accept the offer that's been made to them.
Yes.
Is that what it comes to?
Yes. Yes. Now, the fourth point is this. The question, my lords, that you have to determine is whether the tribunal's conclusion of fact, which they made in paragraph 51, that the force majeure event could be overcome by reasonable endeavours, was infected by an error of law. Because, as Mur contends, and the learned judge below held, the expression reasonable endeavours can never require a party to accept non-contractual performance, even of a currency obligation, and even where the currency offered was the commercial equivalent of the contractual currency. And I say it was the commercial equivalent here because RTI had offered to bear any exchange rate loss and any other costs that were associated with transmitting euros as opposed to dollars, which was the currency of the COA.
I'm sorry to interrupt again at an early stage, but if all Mur have to do is to accept the offer made to them, does this case actually have anything to do with reasonable endeavours? Is not the question whether the problem, to use a neutral term, is overcome by payment in euros and then conversion into dollars. If it is, you win. If it's not, you lose.
Well, my lord, that is a very simple and straightforward way of looking at the issue. It was contended by my learned friend before the learned judge that everything turned upon the meaning of reasonable endeavours, and that he could never, or his clients could never be required to accept a tender of non-contractual performance. We have always contended that the clause simply requires parties to act reasonably. The tribunal has made a finding of fact that it was entirely reasonable for euros to be offered on the terms that RTI did, because that presented no detriment to Mur.
Well, it goes further than acting reasonably. You have to overcome the problem. And if, however reasonably you act, you don't overcome the problem, then you're in trouble. But if you do, then one goes to a second stage. Well, is it reasonable to require you to do that? And if all they have to do is to accept an offer, you might think the answer is yes. And anyway, once you get that far, reasonable perhaps does become a question of, which is why I framed the question as I did. It's very early days, but that's just
my lord, I fully take on board your point, and we would respectfully submit that it's one thing for Mur to say that I cannot be required to make an offer that is of non-contractual performance, but it's quite another for Mur to refuse an offer of non-contractual performance that has been found to be entirely reasonable by the trier of fact. All they have to do in order to enable the contract to continue in operation and loading and discharge to continue unaffected is to agree to the reasonable offer that RTI have made, which is to provide the commercial equivalent of US dollars.
Do I understand that on your case, Mur will be obliged to accept any non-contractual performance, provided only that it was reasonable.
Yes, yes. I mean, we have a broad case and a narrow case. The narrow case focuses on currency, and that obviously is what our case is about. But it does extend to a broad case too, because the principle that Mur contended for extends to never being obliged to accept non-contractual performance of any obligation.
Can I just try to clarify? So suppose there's a contract that requires something to happen by a particular date, say the 1st of January. And suppose that endeavours could achieve the result on the 2nd of January. And suppose that commercially it made no difference to the other contracting party whether it was the 1st of January or the 2nd of January. On your case, would D apply?
Yes, it would. If the trier of fact found it was reasonable and it was commercially equivalent performance and it was designed to achieve the overall objective of the force majeure clause, which was to facilitate performance of the contract, then yes.
And suppose now that the result couldn't be achieved on the 2nd of January, but it could be achieved by the 10th of January. The same principle?
Same principle, but again, depending on fact. It may be that there are particular considerations that would mean that after 10 days' delay, it would not be reasonable to accept that. But it's all a question for the tribunal of fact, weighing into the balance the fact, one, that it's non-contractual performance, but that's only one of the factors. You have to look at all of the relevant evidence, much as you would do with mitigation and looking at all of the factors that would impact upon whether a party's conduct was reasonable or not. So I think I was on my 5th point, my lords. Mur's argument, which found favour with the learned judge, has very far-reaching consequences, because if it's correct, it would enable any party to cling to its contractual right to receive payment in a particular currency in order to suspend performance under a contract where there is a force majeure event delaying or preventing payment in the contractual currency, even where payment can be made in another currency with no detriment to the receiving party. Because reasonable endeavours on Mur's case do not and cannot extend as a matter of law to accepting a non-contractual currency.
But is that necessarily correct? Because doesn't all of this arise out of the arbitrator's finding of fact that there was causation in the present case? And it wouldn't necessarily be the case in every situation of a problem over currency of payment that there was causation.
I'm looking at the facts of this case. In this case, the only impediment to loading and discharge was Mur's insistence on having a free flow of money to pay for loading and discharge operations.
To be sure, and one might have thought that that wasn't really a problem, but the arbitrators found otherwise.
Well, the arbitrators found that the force majeure case succeeded in all respects, save for reasonable endeavours. But the reasonable endeavours obligation also imports a causation requirement, because you have to look at whether it is the reasonable endeavours that would enable the problem to be overcome, and whether in fact the refusal to accept those reasonable offers of alternate currency was an independent cause of the prevention of loading and discharge. And because of the close correlation between reasonable endeavours and the need for that to be linked to alleviating prevention or delay in the loading of the cargo at the load port and or the discharge of the cargo at the discharging port within 36.3b, you've got to look at causation too. And my submission will be that if a party unreasonably rejects an offer to be paid in the commercially equivalent currency, with all exchange rate losses being met by the paying party, it becomes a case where the effective cause of the prevention of or delay in loading of cargo at the load port and or discharge of the cargo at the discharge port is Mur's conduct. It's no longer the monetary
submission
restriction.
open to you on this appeal?
Well, my lord, I would submit that it is, because it's certainly part of Mur's argument that reasonable endeavours and causation are part and parcel of the same coin. And so it must be relevant to look at causation issues from that perspective. The sixth introductory point is that, as the tribunal has found, again, award paragraph 50, Mur did in fact go on to accept euros from RTI in payment without rejecting them. And we say that that is consistent with and indicative of what commercial parties would expect to be the result of a clause obliging Mur to use reasonable endeavours to overcome delays in the transmission of US dollars. Mur's construction, which found favour with the learned judge, effectively denudes clause 36.3d of content and meaning in the context of restrictions on currency. And that is a very surprising result, particularly given that 36.3d was specially negotiated and added in the recap. My seventh point is that the construction of clause 36.3d, which has found favour with the judge, requires the court to hold as a matter of construction either, little 1, reasonable endeavours bears a special meaning, such that, as a matter of law, it can never be reasonable to expect a party to accept non-contractual performance, however reasonable or commercially equivalent that alternative performance might be. Or, little 2, clause 36.3d must be read as subject to an implied exception, whether by way of implied term or otherwise, in respect of any form of non-contractual performance. Now, the eighth point is that there is no academic text that anyone has been able to find, or reported case that anyone has been able to find, that states that reasonable endeavours cannot, as a matter of law, include non-contractual performance. And that's telling. The ninth point is that RTI's case, my client's case, is that as a matter of construction, the phrase reasonable endeavours in clause 36.3d bears its ordinary and natural meaning. In other words, efforts which, on the facts of the case as found by the trier of fact, are held to be reasonable, and that there is no warrant for restricting that meaning or implying any term that restricts that ordinary and natural meaning. I'll develop that a little further when I come on to consider issues of construction. And the 10th introductory point is, accordingly, because the question of whether taking a particular course of action would have constituted reasonable endeavours is one of fact, to be arrived at upon an evaluation of all of the evidence, the tribunal's finding in paragraph 51 of its award should be restored, and the appeal from the judgment of Mr. Justice Jacobs allowed. So, my lords, those are my introductory points. I'd now like to take you, if I may, to key findings in the award so that you have them in context, you'll find the award in the core bundle, tab 7, starting at page 110. And you may also need to have the supplementary bundle open at tab 2, because there you have the clarification that the tribunal gave after it published its award. If we can go first to paragraph 34, the tribunal sets out the background of the governing legislation that constituted the monetary restriction. And they say it's set out in CATSA, an Act of 2017, OFAC, and that's the US Department of the Treasury Office of Foreign Asset Control, can sanction individuals, officials and their affiliated companies. On the 6th of April 2018, OFAC sanctioned Mr. Oleg Deripaska, who was then the president of Rusal, and a number of companies that he directly or indirectly controlled. At the same time, to minimise disruption to existing contracts, OFAC would regularly issue regulatory exemptions, referred to as general licences, which allowed companies and individuals to carry out certain transactions with the designated parties. We can see in paragraph 35, last couple of lines on page 127, that OFAC provide guidance to parties by publishing answers to frequently asked questions. And in FAQ 545, which was published in 2017, OFAC had stated that a transaction is not significant if US persons would not require a specific licence from OFAC to participate in it. And that same guidance was effectively repeated in FAQ 574, which was published contemporaneously with the applicable currency sanction, and FAC 579 published on the 23rd of April.
When in paragraph 34 it says sanction Mr. Deripaska and a number of the companies he directly or indirectly controlled,
yes.
Should we understand that as including RTI?
No, RTI were not sanctioned, and indeed there wasn't a sanction preventing payment in dollars, as we will see. It was merely a factor that would lead to banks in the US being cautious about allowing transmission of dollars through the banking channels until they could verify that it was an authorised transaction or not one that was prohibited by the sanction. And the tribunal go on to deal with their findings on that.
Okay, thank you.
Then we go on to para 36 on page 128. OFAC's General Licence 12, which was issued at the same time as the designation of companies, including Rusal, on the 6th of April 2018, authorised US persons and those subject to US jurisdiction to carry out all transactions and activities that are ordinarily incident and necessary to the maintenance or wind down of operations, contracts or other agreements until the 5th of June 2018. And on the 23rd of April 2018, General Licence 14 extended that permission to maintain or wind down activities to the 23rd of October. And then we go on to paragraph 40, which deals with the agreed propositions between the US law experts, that as per FAQs 545 and 574, Mur's performance of the COA transactions would not have constituted significant transactions under section 228 of CATSA if a US person in Mur's place had qualified for GL12. The upshot was, therefore, that performance of the COA fell within GL12 and was permitted. If we then go on to paragraph 41, the experts go on to say this: performance of the COA transactions consistent with general practices applicable to the COA, ... would have been considered activities and transactions ordinarily incident and necessary to the maintenance or wind down of the COA within the meaning of GL12. And then in the second paragraph, they confirm that to the extent that the general practices applicable to COA transactions called for the engagement of third parties, such as bill of lading holders or receivers, the creation or maintenance of such third-party relationships as part of the COA transactions are themselves activities and transactions ordinarily incident and necessary to the maintenance or wind down of the COA within the meaning of GL12. So we have a conclusion that performance of the COA fell within GL12 and was therefore permitted. And we have paragraph 43, which is to be read with the clarification added at tab 2 of the supplementary bundle. And I'll read paragraph 43 with that clarification wording added. However, the position summarised in paragraph 41 above emerged only after the exchange of detailed expert evidence and a careful consideration of all aspects of the COA. The effect of primary and even secondary sanctions is drastic. Normal commercial counterparties will be frightened of trading with the party that has been sanctioned. Bank finance is likely to be frozen and underwriters will be reluctant to ensure normal trading activities. Consequently, Mur were prima facie perfectly entitled, subject to consideration of whether the force majeure event could have been overcome by reasonable endeavours, to take time to review the position and opt for caution by only reinstating the COA once General Licence 14, which allowed the activities to continue beyond the end of the COA period, had been issued. The second point to draw from the analysis in the award is that US dollar payments were in fact permitted under the COA. This appears from paragraph 44. With regard to the effect of the sanctions on dollar payments, we preferred the evidence of Mr. Smith, who was RTI's expert, that no penalties would have been imposed because if the exemption granted by GL12 applied to the performance of the COA, it would also have permitted US dollar payments under the COA. The third important point emerges from paragraph 45. In essence, paragraph 45 holds that notwithstanding that US dollar payments were permitted under the COA, there was a probability that US dollar payments to Mur routed through a US intermediary bank would initially have been stopped until the bank could investigate whether the transaction complied with US sanction requirements. And you'll see the terms in which they record that agreement.
They refer there to RTI's status as a blocked party. I thought you just told us that
RTI was not itself a sanctioned entity. However, because it was a company directly or indirectly associated with Mr. Dneprobugsky, who was then the president of Rusal, which had been sanctioned, the banks would have been cautious about ensuring that there was no inadvertent breach of sanctions, leading to a delay in transmission where that was sorted out. So paragraph 45 is as I have set out. The next important point to note is paragraph 50, which sets out the tribunal's reasoning for being satisfied on the facts, but in order to overcome any temporary delay in transmission of US dollars to Mur through US banking channels, that temporary delay could easily have been overcome by RTI transmitting euros to Mur's bank, which would have been credited as US dollars to Mur upon receipt. And you'll note the terms in which they express that. Accepting payment in euros was a much more realistic possibility. It would have presented no disadvantage to Mur because their bank in the Netherlands could have credited them with US dollars as soon as the euros were received. RTI could of course not insist as of right on making payments in euros because their payment obligation in the COA was to pay dollars. However, we were satisfied that it was a completely realistic alternative that Mur could have adopted with no detriment to them, because RTI made it clear in correspondence that it would bear any additional costs of or exchange rate losses in converting euros to dollars, and secondly, a number of payments were in fact made by RTI in euros and converted on receipt by Mur's bank, and there's no evidence that Mur rejected those payments. And the final point is that the tribunal concluded that any force majeure event could be overcome by reasonable endeavours. They set that out in paragraph 51 as a consequence of their factual finding in relation to acceptance of payments in euros. My lords, if I can now, having looked at the award, turn to consider the judgment of Mr. Justice Jacobs, which you'll find in the core bundle at tab 5, starting at page 57. And at the outset, can I say that I don't think we need to concern ourselves with paragraphs 70 to 83, which relate to respondent's notice point 1, which was that the COA didn't require payment of freight in dollars. That point is not pursued on appeal, and no permission was sought or obtained for that. Nor do we need to consider paragraphs 132 to 170, which relate to respondent's notice ground 2, which is set out in paragraph 10.2. Nor do we need to look at paragraphs 187 to 191, which is respondent's notice point 4, or paragraphs 132 to 170, which relate to respondent's notice ground 2. So the essential paragraphs are the balance. The key paragraphs are 55 to 60 and 85 to 131, which summarise the parties' arguments and set out the judge's reasoning. Now, as the judge notes, RTI maintained below and continue to maintain in this court both a broad argument and a narrow argument. The Charterer's broad argument that when addressing reasonable endeavours, the significance of any contractual obligation, including one relating to identification of load ports or discharge ports or particular cargoes, is simply one of the factors to be weighed in the balance in deciding the overall question of reasonableness and reasonable endeavours in 36.3d. And the judge considered that in paragraphs 85 to 108, under the heading, the Charterer's broad argument. And as one can see, he starts by looking at Bullman and Fenwick and the Vancouver strikes cases, rather than starting off with a traditional construction and interpretation exercise. The judge rejected RTI's argument on the basis of his view that the decision of this court in Bullman and Fenwick, decided over a century ago, and the decision of the Court of Appeal and House of Lords in the Vancouver strikes case, decided again some considerable time ago, show that a party can never be required to accept non-contractual performance in order to overcome the effect of a force majeure event as part of a reasonable endeavours obligation. He deals with Bullman in those terms at paragraph 98 and at paragraphs 104 and 105 in relation to Vancouver strikes. Now, I'll have something further to say about those authorities and that analysis in due course. But the main point to draw is that Bullman and Fenwick and Vancouver strikes are very different cases, concerned with very different issues, were argued by reference to very different facts, and those cases should not have been treated as the basis for interpretation of a very different force majeure clause, such as one we have here with the specially negotiated sublim D. Now, RTI's narrower argument, which addresses whether non-contractual performance can be required as part of reasonable endeavours in relation to currency of payment is addressed in the judgment at paragraphs 109 to 114. And the judge rejects it largely on policy grounds, alluding to considerable uncertainty that would result if different treatment were given to currency obligations, and more generally, if matters of this sort were left to tribunals of fact. He considered that there's no warrant for differentiating between the importance of a contractual obligation to pay in a certain currency and a contractual obligation to load a particular cargo at a particular port, such that the decisions in Bullman and Vancouver strikes should apply even to this very different factual situation. So it doesn't allow for any nuanced application of factual considerations that would bring to bear on the question of overall reasonableness. The judge deals with the authorities which RTI relied upon by way of analogy in paragraphs 115 to 131, including the authorities on mitigation and New York Arbitration Award, which he doesn't actually address because he didn't consider it provided any assistance at all. I'll address that reasoning in more detail when I come to look at the cases that he refers to. So if I can now then turn to my third issue of principle, which relates to principles of construction that apply to ascertaining the meaning of reasonable endeavours. First point is this: the normal principles of construction and interpretation of commercial contracts apply. Therefore, applying the guidance of the Supreme Court in Arnold and Bennett and Woods and Capita, the court's task is to consider what a reasonable person who had all the background knowledge that would reasonably have been available to the parties at the time of contracting would have understood the parties to mean in clause 36, and in particular 36.3d, when using the phrase reasonable endeavours. Now, if there are two possible constructions, then the court is entitled to prefer the construction which is consistent with business common sense. And this reflects what we've said in our skeleton, in particular at paragraph 9. Now, a convenient synthesis of the approach which the court should adopt to construction generally, applying Arnold and Wood, has been formulated in the Ocean Neptune, and you'll find that in your authorities bundles at tab 22 in Chitty on contracts at page 620. Paragraph 15 and 53. And if I can just read that. Court's task was to ascertain the objective meaning of the language which the parties have chosen in which to express their agreement. The court must consider the language used and ascertain what a reasonable person, that is, a person who has all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the contract, would have understood the parties to have meant. The court must consider the contract as a whole, and depending upon the nature, formality and quality of drafting of the contract, give more or less weight to elements of the wider context in reaching its view as to the objective meaning of the language used. If there are two possible constructions, the court is entitled to prefer the construction which is consistent with business common sense and to reject the other. Interpretation is a unitary exercise in striking a balance between the indications given by the language and the implications of the competing constructions. The court must consider the quality of drafting of the clause, and it must also be alive to the possibility that one side may have agreed to something which with hindsight did not serve his interest. Similarly, the court must not lose sight of the possibility that a provision may be a negotiated compromise, or that the negotiators weren't able to agree more precise terms. This unitary exercise involves an iterative process by which each suggested interpretation is checked against the provisions of the contract and its commercial consequences are investigated. It doesn't matter whether the more detailed analysis commences with the factual background and the implications of liable constructions, or a close examination of the relevant language in the contract, as long as the court balances the indications given by each. Now, we have set out in our skeleton at paragraph 10, which is in tab 3 of the core bundle, at page 37, specific principles which have been developed in relation to construction of force majeure clauses. And we've cited the relevant academic text which bears them out. So, as we can see, the party seeking to rely on the clause bears the burden of proving that it applies. Force majeure clauses are construed narrowly. Clear words are required to shield a party from what would otherwise be a liability and damages for non-performance. Ambiguity is to be resolved against the party seeking to rely upon a force majeure clause. That's Lord Justice Longmore in The Crude Sky. In each case, the question is one of interpretation of the particular clause, and care must be taken to avoid drawing conclusions of apparently universal application from a case which turns on the wording agreed by parties in the context of a particular force majeure clause. If I can just pause there, Mr. Justice Jacobs appears to have overlooked that fundamental rule because he has translated principles that he's derived from Bullman and Fenwick and the Vancouver strikes cases and converted them into principles of universal application without starting from the first premise, which involves construction of clause 36. And then little f in paragraph 10, there's no justification for supplementing the ordinary meaning of words in a force majeure clause with additional rules for their application, such as a rule that would limit the application of force majeure clause to events or states of fact not in existence at the date of the contract, or to those which are unpredictable at the time it was made. Just pausing there, the learned judge has indeed, in the approach he's adopted, created an additional rule for the application of 36.3d by requiring reasonable endeavours to be caveated with a requirement that they can only involve acceptance of contractual performance. So
what words are we trying to construe? You're focusing on, you said this heading, your heading was the principles applicable to the meaning of reasonable endeavours.
Yes, so we're looking at D.
Is there any question about the meaning of reasonable endeavours as distinct from the question of what is meant by overcome? You might overcome something by providing something equivalent, or you might only overcome it by achieving contractual performance. And if there are two possible meanings there, doesn't your principle D suggest that you go for the narrower approach?
Well, principle D shows that because it is Mur that is seeking to rely upon the force majeure clause, you give it a narrow ambit. And Mur's argument has been and remains that reasonable endeavours within little d do not require anything involving non-contractual performance. So it has very much been the case that reasonable endeavours are being given a specific gloss as a matter either of interpretation, or there is some implied restriction which can only come in as an implied term that limits the meaning of reasonable endeavours to those which, as a matter of law, are directed.
But it must be reasonable endeavours to achieve something, and the something which has to be achieved is the overcoming
of the restriction,
the problem.
Yes.
I just I wonder whether the question is, as I said before, what is meant by overcoming the restriction or overcoming the problem?
My lord, again, we would say that as a matter of the natural and ordinary meaning of those words, it is conduct that is designed to ensure that the monetary restriction, which in this case is a temporary delay in the transmission of US dollars, does not hold up or prevent loading and discharge of cargo. Now, if Mur had accepted the offer that RTI reasonably made, which involved no detriment to Mur and was effectively the commercial equivalent of payment in dollars, there would have been no impediment to loading and discharge of cargo, and the monetary restriction would have been overcome.
Can I just understand that in the context of the clause? As you say, we get the clause set out in paragraph 19 of the judge's judgment.
Yes.
And so we start at D, that says it cannot be overcome by reasonable endeavours. And the it is the force majeure event.
The force majeure event and its effects, because that's what the purpose of this is to achieve. It's designed to overcome the effect of a force majeure event. So it refers to the force majeure event and its effects.
So is that right as a matter of construction? I mean, it may come to the same thing, but if we look at 36.3, it says a force majeure event is an event or state of affairs which meets all of the following criteria. It cannot be overcome by reasonable endeavours. So it seems that it's the force majeure event which has to be overcome.
But applying a commercial construction, bearing in mind what the objective of the parties clearly was when inserting this in their contract, it was to facilitate continued performance of loading and discharging under the COA. And if you have an impediment in the form of a monetary restriction, such as that contemplated in C, that's imposed by a government, which is the typical factual scenario that we are likely to encounter, the it must refer to the effects of the force majeure event, because how can one alter a government's decision? One can only overcome the monetary restriction if you are using efforts directed to avoid or overcome its effects.
And there is a Canadian... I'm sorry to interrupt you, yes. but the word it is common to all four paragraphs. So in A, it is outside the immediate control of the party. B, it prevents delays. C, it is caused by. D, it cannot be overcome. I assume you would accept that the word it has the same meaning in each paragraph.
My lord, it certainly comprises the force majeure event, but if you are applying a purposive construction, having regard to the objective that the parties obviously desired to achieve by this clause, what they are trying to do is to impose an obligation to overcome the effects of force majeure events by reasonable endeavours, and indeed that would be implicit.
So, to be clear, are you submitting that the word it in paragraph D has a different meaning to the word it in paragraphs A, B and C?
It within A, B and C also would comprise the effects flowing from the event. So the force majeure event is an event or state of affairs which meets all of the following criteria. It and its effects are outside the immediate control. It and its effects prevent or delay loading. It and its effects are caused by one or more of the following. It and its effects cannot be overcome.
So you're writing in and its effects into each paragraph.
Well, it's not writing it in as one would do if one were implying a term. It's looking at what the parties must reasonably have intended the function of this clause to be. And indeed, the Canadian appeal case, which is cited in our authorities, it's the Actor case, which I think is at tab 14 of the authorities. At paragraph 29, and I'll give you the page reference in the bundle, page 380. Paragraph 29 having previously observed that the matter is all about mitigation, and I'll show you the actual clause, it's in the head note, page 369. The agreement to find force majeure as including breakages of or accidents to plant, machinery or lines of pipe, pipeline connections, pipeline repairs, not within the control of the party claiming suspension, and which by the exercise of due diligence such party is unable to overcome. And then one goes to the judgment at paragraph 29. What is said is this. In my view, a force majeure clause is all about the effect of the event, not simply the occurrence of the event. It follows that the intended meaning of the words is that in paragraph 9a, which says any cause not within the control of the party claiming suspension, and the effect of which by the exercise of due diligence such party is unable to overcome. I therefore conclude the supplier has a duty to mitigate.
So something's gone wrong there, hasn't it, in that last sentence, unless I'm being obtuse. It doesn't seem grammatically to make sense. So what does, well, for a start, it opens some brackets, opens some inverted commas and never closes it. So what should it read?
Paragraph 9a. Let me see if I can find it better. Yes, paragraph 9a, page 372, is the fuller version of the clause. And it's the last two lines which I think the judge is interpreting in the way that's set out in paragraph 29, because the clause, the last two lines say, not within the control of the party claiming suspension, and which by the exercise of due diligence such party is unable to overcome. And the judge in paragraph 29 is saying, it follows that the intended meaning of the words is that in para 9a, cause not within the control of the party claiming suspension, and the effect of which by the exercise of due diligence such party is unable to overcome. So he's interpreting it to mean adding those words in. That's effectively what I suggest should be the result here.
And what I'm not quite sure why. If we go back to 36.3,
yes,
the force majeure event is an event or state of affairs. Little a, it's outside the immediate control of the party. I mean, why should one treat that as anything other than the force majeure event is outside the immediate control of the party?
Well, I'm apprehending an argument that may be raised that it's never possible to overcome a monetary restriction itself if by that you are meaning revoke the restriction, because there's simply no ability to do it. And so what I would suggest the true construction of this is that when you're looking at monetary restrictions, you don't say, well, little d has got no application. You've got to give it some sensible meaning, and it's overcoming the effect of the monetary restriction.
Is that a real dilemma in this sense, that suppose you take a case such as this one where there are sanctions imposed, but there's a licensing regime. On any view, D has a potential meaning because you can apply for a license. So you can't just say, oh, there's a sanction, there's a force majeure event, because you can overcome it by getting a license.
But here, of course, that was not necessary because there was a general license which permitted the activities to continue.
And I follow that.
Yes.
But in terms of the issues of construction, one has to look at what situations might arise. And if the force majeure event is the imposition of a sanction, then it's not impossible to think of circumstances in which D would apply on any view, because you can apply for a license.
If the facts had been such that it was the absence of a licence that had caused the restriction, then that is correct, my lord, I would accept that. But here there was no need to apply for a licence because there was a general licence, number 12, issued at the same time as the SDN designation of Mr. Dneprobugsky took place on the 6th of April 2018. And this was never a case of a COA that could not lawfully be performed.
No. And just to be absolutely clear, what do you take the force majeure event here to be precisely?
It's the monetary restriction which the experts were agreed was the practical effect of passing US dollars through an intermediary bank in the US, which is set out in paragraph 45 of the tribunal's reasoning, which reads, in the event RTI was required between the 6th of April and the 23rd of April to make any US dollar payments to Mur that passed through an intermediary bank in the US, which is highly likely, it's highly probable that the US intermediary bank would initially have stopped the transfer on the basis of RTI status, or they say as a blocked party, until the bank could investigate whether the transaction complied with US sanctions requirements. It may be that in that sense it's correct to regard RTI as a blocked party, albeit they were not sanctioned and they were permitted to carry out the COA.
Yep.
So in the present case, does it not follow that the it is the stopping of the transfer by the US banking system?
Yes. Yes.
Yeah.
Yes, my lord. So reverting to the principles of construction, I think I've made the point already that it isn't a legitimate approach to construction of reasonable endeavours clause in this case to argue by analogy with other authorities, particularly those that have got nothing to do with force majeure clauses or an express reasonable endeavours provision. Now, the judge in this case has deduced a principle of apparently universal application, namely that reasonable endeavours can never include accepting non-contractual performance or non-contractual currency, from the Bullman and Vancouver Strikes cases, which are very different on their facts. They concern the interpretation of a strikes exception clause and not a force majeure clause. And if I can keep on the same theme and make the following point by reference to an extract in Chitty, which is at tab 26 of your authorities, starting at page 710. Paragraph 26062 is headed Force Majeure Clauses Assume a Variety of Forms. And it says force majeure clauses may assume a variety of forms or are of different kinds. This being the case, it's important not to seek to deduce propositions of general or universal application from cases which turn on the wording of a particular force majeure clause. So, for example, while the force majeure events are typically events beyond the reasonable control of parties to the contract, if a particular contract clearly includes within the list an event which is within the reasonable control of the parties, then a court called upon to interpret the clause should give effect to it as it stands and conclude that the event qualifies as a force majeure event for the purposes of that particular clause, even if it's an event within the control of the party concerned. And then we have the reference to Mr. Justice McCarty in Le Beaupin and Crispin, where he said a force majeure clause should be construed in each case with a close attention to the words which precede or follow it, and with a due regard to the nature and general terms of the contract, such that the effect of the clause may vary with each instrument. And that's very important. It does make the judge's analysis, with all due respect, and Mur's argument before him, which persuaded him, heterodox, because the analysis has proceeded from the basis that Bullman and Vancouver Strikes dictate the principle that should be applied to the interpretation of the force majeure clause in this case, even though neither Bullman nor Vancouver Strikes was a case concerning a force majeure clause or a currency obligation within it, and where the facts were obviously very different. Now, we strongly take issue with Mur's proposition at the end of paragraph 22 of their skeleton, where they say that rules of contractual construction are unlikely to assist. We say rules of contractual construction are central. And that is the correct way to approach the meaning of 36.3d, rather than rationalising from other cases with different clauses. Now, the learned academic Mr. Peel has written a section on reasonable endeavours, which we find at tab 34 of our bundle in Peel on force majeure and frustration. And at paragraph 12045, which we find at page 780 of your bundle, he discusses the obligation to use reasonable endeavours. And it's telling that there is no formulation of a general principle such as that which is found favourable by the judge. What he says is this: we have seen in the paragraph above that an event is not beyond the control of a party relying upon it, if it could have been avoided by taking reasonable steps. In some cases, the clause may make express provision for the parties to take such reasonable steps or use their reasonable endeavours. In Cedral Garner and Tullow Garner, Mr. Justice Tier held that the obligation in that case to use reasonable endeavours to mitigate, avoid, circumvent or overcome the circumstances of force majeure arose when there has been a force majeure, i.e. it was necessary first to decide if there had been a force majeure event, in that case a drilling moratorium imposed by the government, and if there had been, whether the parties had used their reasonable endeavours to ensure that the force majeure doesn't prevent them from performing their obligations under the contract. In practice, the distinction which appears to be drawn, if intended, may be illusory. An event only amounts to force majeure if there is at least some link between it and a party's failure to perform, for example, an event preventing fulfilment. And if, through the taking of reasonable steps, performance is still possible, there is no force majeure. In some cases, however, it may be that the event itself could have been avoided by taking reasonable steps. See the example of the strikes referred to above, while in others, the event could not reasonably have been avoided, but its effect on performance of the contract could have been. In
so pausing there,
yes.
He seems to be envisaging here contractual performance. Is that not right?
It's envisaging continuing performance of the obligations under the underlying contract. Yes.
In accordance with the terms of the contract.
Well, it all depends. I mean, it's not here said that the reasonable steps can only be directed in a manner which is consistent with the four corners of the contract. What is being said here is that reasonable endeavours require the party to take reasonable steps to avoid its consequences.
Well, the sentence previous to the one you've just read, he says, if through the taking of reasonable steps, performance is still possible. So he must there be contemplating contractual performance, mustn't he?
It depends which particular contractual obligation you're looking at. I mean, contractual performance in our case involves the loading and discharge of cargoes and the paying of freight and demurrage for them. In order for that to proceed, where you've got a temporary restriction on a currency, will require reasonable steps, which won't necessarily be requiring you to tender and accept the currency of the contract, where you can overcome the effect of the restriction by the simple expedient of the commercially equivalent substitute. It all depends on the facts, is what I'm saying. And if indeed the court or any author was intending to espouse a principle such as that which Mr. Justice Jacobs has developed, it would be stated in very clear terms. It would be stated, it is never possible for reasonable endeavours to comprise acceptance or tender of non-contractual performance. But it all depends on the facts. And Mr. Justice Tier, and indeed Peel at the end of page 780, say what is required by reasonable endeavours is a further question of construction and dependent on the context in which the obligation arises. According to Mr. Justice Tier in Seadrill, in the context of a force majeure clause, the mere fact that a step is contrary to a party's commercial interests is insufficient to show that it has exercised its reasonable endeavours.
I mean, the snag with that, at least, I mean, I haven't looked at Mr. Justice Tier's decision, but if you go back to what has been quoted here, back in 1245, we get Mr. Justice Tier referring to whether the parties have used their reasonable endeavours to ensure that the force majeure does not prevent them from performing their obligations under the contract. And performing their obligations is consistent with the judge's approach, isn't it?
But you're having to construe it by reference to what is the object of the clause. Is the object of the clause designed to ensure receipt of US dollars, come what may, which, if it can't be achieved without delay, may result in effectively the suspension of the whole of the COA, achieving a result equivalent to frustration? Or is it designed to facilitate reasonable steps to overcome what the relevant impediment is? And it doesn't necessarily have to be imposing a straitjacket of accepting the contractual currency when there is no material difference in the alternative performance that is offered.
Can I just sort of think
Yes.
around it for a moment? You've got to a situation. No, I think I'll defer that discussion. Thank you.
Thank you. So we do say that although there may be inferences that my learned friend can point to, which he may say, well, suggests that you're looking at reasonable endeavours directed to ensuring contractual performance, there is no textbook or case law that sets out any principle that restricts the meaning of reasonable endeavours to acceptance of contractual steps directed to overcome a force majeure event. And the ordinary and natural meaning, we say, of reasonable endeavours doesn't imply a restriction on what can qualify. It may be instructive to have a look at the relatively recent decision of the Court of Appeal in National Bank of Kazakhstan, which we cited in our skeleton at paragraph 20. And it's at tab 21 of the authorities bundle, starting at 599. And as you can see from the headnote, this was an appeal by the National Bank of Kazakhstan and the Republic of Kazakhstan for the decision of Mr. Dneprobugsky, as he then was, dismissing their claims to declaratory relief as to the effect of orders made by the Dutch and Belgian courts on their banking relationship with the respondent, Bank of New York Mellon, London branch. BNYM was incorporated in Belgium with a branch in London. Then there was a contract governed by English law with non-exclusive jurisdiction, clause 16(1) of which provided that BNYM would not be liable for, and no default would be caused by, any delay or failure on its part to perform any obligation which, in whole or in part, arose out of or was caused by circumstances beyond its direct and reasonable control, including without limitation any order imposed by any judicial authority. So those are fairly wide words, any order imposed by any judicial authority. We then come to the facts. There was a businessman, and indeed others, called the Stati parties, who had obtained a Swedish arbitration award against Kazakhstan for a very large sum of money. And as a prelude to enforcing that award, the Stati parties obtained interim relief from the Dutch and Belgian courts against BNYM by way of attachment and garnishment orders. And the issue was whether those orders fell within the scope of clause 16(1). In particular, any order imposed by any judicial authority. Then, as we can see from the headnote, matter of language, those orders clearly fell within the terms of 16(1). The clause was drawn in wide and unqualified terms. It applied to any order by any judicial authority, not limited to domestic court orders or foreign court orders for a particular type of status. The causal test to be applied was also drawn in broad terms. The clause was clearly intended to have extensive exculpatory effect. Causation requirements of 16.1 provided a limit to its scope of application, and there was no need to read in some further limit, such as that the order would have to be recognised and enforced by the English court applying English law. And then headnote 3, the appellant's interpretation had the uncommercial consequence of exposing the BNYM to the risk if the court orders were not complied with the criminal and civil liability in connection with the dispute, which had nothing to do with BNYM. If we go to the paragraphs of the judgment, the appropriate sections start at paragraph 37, where we can see that Lord Justice Hamlin starts by looking at matters from the perspective of the proper approach to construction, looks at Arnold and Britain, Wood and Capita, and then he goes through the relevant tests. He then looks at textual considerations from paragraph 41 onwards, and at 44 he says the respondent's case is that any means any, and that there's no reasonable justification for reading down the clear words used as the appellant's construction requires. Although the appellants say this is a matter of interpretation, their construction does require limiting words. On the appellant's case, any order means any order which will be recognised and enforced by the English court applying English law. And then 46, the causation requirements of 16.1 provide a limit to its scope of application. No need to read in some further limit. And then 50, if we look halfway down, assuming without deciding that clause 16 is to be treated as a force majeure clause, the principles that such clauses are to be construed strictly, and that it's for a party relying on a force majeure clause to show it clearly applies, don't assist. This isn't a case involving ambiguity, it's a case which concerns which of two rival interpretations is the correct interpretation of 16.1. And then we go to contextual considerations, and the court derives little assistance from that, paragraph 59. And then we go to 74, where the court concludes, I agree with the judge that the language of 16.1 is clear and subject to causation, it applies to the Dutch and Belgian orders. The appellant's construction clause requires it to be read down and subject to an important limitation. Their arguments based on contextual considerations and uncommercial consequences don't justify this, even if it's correct to regard it as a matter of mere interpretation. So that is a conventional approach to construction of a clause.
So what proposition relevant to our case do you get from national?
The proposition is that you don't read down wide words with an implied proviso that isn't there in the language when the clause makes sense on its own, applying traditional principles of construction and interpretation. So that's the approach which we say the judge here failed to adopt. Rather than looking at Arnold and Britain, Woods and Capita, now the Ocean Neptune, and looking at this iterative process of checking rival meanings, he launched effectively into Bullman and into Vancouver strikes and tried to derive a principle of universal application from those cases, which was then shoehorned to inform what he believed to be the constraint in 36.3d, which was not there as a matter of language and certainly would not be implied. For the Mur principle to apply, we submit it would be necessary for the court to imply a term excluding acceptance of any form of non-contractual performance from the scope of best endeavours, because it isn't there on the express wording.
Can I just ask a stupid question, which I'm sure the answer to is apparent from what you've already taken us to. But your contractual obligation was to pay in dollars.
Yes.
Is there a finding that you couldn't do that?
The only finding is that there would have been a monetary restriction and that Mur were not willing to load or discharge while that monetary restriction was in place.
And that I follow. But we're concerned to an extent with the question of whether the performance you could have offered complied with the contract. You've explained that there was no restriction under the sanctions regime with you paying in dollars. So why wouldn't you have been able to perform your contractual obligation and pay in dollars?
Because Mur would not accept it. Perhaps we could go to the judgment, because...
No, it wasn't. On the contrary, Mur wanted to accept dollars. That was their whole position. The problem was that your payment was going to get held up in the US banking system.
But the reason they were not willing to load and discharge was because of their insistence on receiving dollars, which was not going to be possible without delay because of the problem with the monetary restriction.
And that I entirely follow. But if we get to the further question of whether these endeavours would have meant that you could comply with your contract, I'm not quite sure why you couldn't comply with your contract. You could pay in dollars.
On the basis
the
there
money
would have
might
been
be
delay.
held up.
Yes, but
there
I
was
mean,
no legal bar to your paying in dollars.
But Mur refused to accept that performance. And if one goes to...
I mean, you could have presumably initiated the payment rather earlier than you did, which would then cater for delay in the banking system. I mean, the arbitrators don't go into that, but why not?
Well, I mean, the findings of the arbitrators, which in fact are summarised by the judge, record the sequence of events as follows. So it's paragraph 24 of the judgment. You have 6th of April 2018, OFAC adding Rusal to the SDN block person list. You then have the 7th of April, a senior person within Mur asking, do we have a sanctions clause that could release us from the COA? On the 10th of April, we have Mur sending a force majeure notice, which says, having reviewed the effect of the sanctions in GL12, we note that the subject to the terms of that licence, it would be a breach of sanctions for owners to continue with the performance of the COA. In fact, that is wrong because the experts and the tribunal's finding was that it was permissible to continue. They go on to say it's not necessary for Mur to load any further cargoes under the COA, and it would therefore be a breach of sanctions if Mur were to do so. Mur's present intention is, however, to continue with the transportation of charterers' cargoes that have already been loaded as detailed above, provided this can be done without breaching sanctions. We further note that sanctions will prevent dollar payments, which are required under the COA. Therefore, as a result of sanctions placed on charterers and guarantors, we are left with no option but to claim force majeure in accordance with clause 36, and it will remain effective for as long as the sanctions remain in place, unless it's possible to obtain relief from sanctions. And on the 14th of April, RTI reject the force majeure notice. They say that sanctions wouldn't interfere with cargo operations and that payment could be made in euros, and that Mur, being a Dutch company, were not a US person caught by sanctions. And then on the 17th of April, Mur emailed their disagreement, commenting that freight is specified in dollars in the recap, and restrictions on monetary transfers is listed as a force majeure event, which might prevent loading and discharging for the very good reason that if monetary transfers from charterers to owners are restricted, owners cannot be expected to load and discharge the cargo without receiving payment in accordance with the COA. RTI continued to protest. In the event, after OFAC issued General Licence 14, Mur resumed nominations on the 25th of April. So that's the way in which matters developed. And as the judge has recited from paragraph 50 of the award, bottom of page 67, after saying that payment in euros was a much more realistic possibility, they find that...
I beg your pardon, where are you now?
I'm looking in the judgment, my lord, paragraph 40, and where
Thank you.
the judge is citing paragraph 50 of the award. And they say much more realistic alternative was that Mur could have adopted with no detriment to them because RTI made clear in correspondence that it would bear any additional costs or exchange rate losses in converting euros to dollars. So it's not a question of RTI behaving unreasonably. They're trying their best to overcome this temporary delay in transmission of dollars, which Mur are making clear is an impediment to their continuing to load and discharge. They're not willing to do it because they think it's unlawful to make dollar payments. That was what their force majeure notice had said, and that's actually incorrect as a matter of fact as found by the tribunal. But they refuse, in the light of what their stance is, which is to decline to accept US dollar payments because they say it's unlawful. They decline the commercial equivalent, even though RTI have taken all steps to remove any detriment to them.
But coming back to my Lord's question, in paragraph 51, and I think we've been over this already, they say, although Mur's case on force majeure succeeded in all other respects, it failed because it could have been overcome by reasonable endeavours.
Yes.
Now, focusing upon succeeded in all other respects, it follows, therefore, does it not, that there's a finding against you that the delay in the system was a force majeure event.
Yes, but the fact that we have won on overcome by reasonable endeavours shows that the tribunal's view was that Mur ought to have accepted the proffered payment, and that the effective cause, because it's the reverse side of the same coin, of the suspension of nominations under the COA was their unreasonable refusal to accept euros.
So subject to D, Mur was entitled to invoke the force majeure clause even though you were in fact able to perform your contract.
That appears to be the result of the findings that have been made. We have only been given permission to appeal in relation to Lim D, which was indeed the same basis upon which my learned friend obtained original permission to appeal from the arbitrators.
So when we come to D, we're addressing ourselves to whether the event could be overcome, and in that context, overcome by something other than contractual performance. But in circumstances where you could, and seemingly were willing, to perform your contractual obligation.
Yes, I mean, the correspondence which is recorded in the award and which is partially set out in the judgment shows that RTI were at all times willing and wanting to continue performance of the COA, and they wanted to try and persuade Mur to continue performance by offering the only practicable alternative solution on the currency point.
Yep.
I think I've just got one or two further points to make in relation to construction before I move on. I was talking about the court having to imply a term excluding acceptance of any form of non-contractual performance from the scope of best endeavours if its construction is to work. Now, the first point is that there was never any attempt to plead or prove such a term, and any attempt to imply such a term would fail on the principles set out by the Supreme Court in the recent Marks and Spencer's case, which is in the bundle at tab 19, starting at page 541, and the relevant paragraphs are paragraph 14 following, and they have been underlined in your copy. Now, terms can only be implied in fact if they satisfy one of two stringent tests. The first is where the implication is necessary to give business efficacy to the contract, and the second test is where the implied term represents the obvious but unexpressed intention of the parties. Now, it's clear that applying either of those tests, any attempt to imply the term qualifying the meaning of reasonable endeavours in the way Mur seeks to do and the judge has done, would fail. And the construction which has been put forward by Mur and favoured by the learned judge effectively enables Mur to prevent performance of the contract through what is on the facts an unreasonable insistence on requiring RTI to transmit payments under the COA in US dollars rather than the commercial equivalent in euros and bear the charges and exchange rate losses concerned. And we submit it cannot have been in the contemplation of the parties in this case when agreeing the force majeure clause and inserting that specially negotiated limb in 36.3D requiring reasonable endeavours, that one party could effectively prevent performance of the COA by refusing a tender of payment that was commercially equivalent. Now, if that outcome had been intended, then I would submit that reasonable endeavours would be meaningless in the context of a force majeure event that consists of the monetary restriction with which we are concerned here, resulting from government action. And it would provide a convenient pretext for escape by Mur from a contract that could easily continue to be performed if the parties act reasonably. Now, you may recall when I was going through the chronology of what happened, that the first thing that Mur does on learning of the designation of Rusal is to send an internal email asking, do we have a sanctions clause that could release us from RTI's COA? So the objective, which is plain from that email, is that they wanted out. There was no genuine desire to continue performance. And although I quite accept that one has to apply an objective interpretation to the meaning of the force majeure clause here, one cannot be immune to the knowledge that if the clause is construed in the way that Mur contend, it will provide a convenient pretext for escape from a contract that could easily continue if parties act reasonably. Now, we've cited in our skeleton, and this is at tab 3 of the core bundle at paragraph 66, an extract from the case of Libyan Arab Foreign Bank against Bankers Trust, which is at tab 13 of the authorities. It may be that we don't need to turn up the case because we've quoted the relevant extract in the footnote. Now, the footnote is Mr. Justice Staunton saying as follows: given that a foreign currency debtor is entitled to choose between discharging his obligations in foreign currency or sterling, I consider that he should not be entitled to choose the route which is blocked and then claim that his obligation is discharged or suspended. I prefer the view that he must perform in one way or the other. So long as both routes are available, he may choose, but if one is blocked, his obligation is to perform the other. Now, when considering currency obligations and how you discharge them, which is at the heart of this appeal as well, the learned judge in our case, sorry, let me say that again. When considering currency obligations, which are at the heart of this appeal as well, Mr. Justice Staunton held that the party, in that case the debtor, shouldn't be entitled to choose the route that is blocked and then claim that his obligation is discharged or suspended. He must perform one way or the other. Now, we say a similar approach should apply here when construing what reasonable endeavours to overcome the event means, because the whole purpose of the force majeure clause is to facilitate continued performance of the COA in the event of an FM or force majeure event. And we say the approach taken in the Libyan bank case is instructive. If Mur is permitted to refuse a commercial equivalent tender in euros, with all associated expenses and exchange rate losses being borne by RTI, then the court is really driven to one of two conclusions. Firstly, the effective cause of the non-performance of the COA would be the unreasonable conduct of Mur in breach of 36(3)d rather than the force majeure event, thus disqualifying Mur from being able to rely on force majeure because it wouldn't fall within B. Alternatively, acknowledge that Lim D has no content in the context of restrictions on monetary transfers and exchanges on the facts of this case, because as a matter of law, no reasonable endeavours can require acceptance of the commercial equivalent of a payment in dollars. Now, we say that stark choice, and looking at the iterative process which is involved in construction, points strongly towards RTI's construction being the correct one. Just to summarise, the context of the force majeure clause as a whole, we say, is directed to facilitating the loading and discharging operations that are referred to in B. That's the purpose of it. the ordinary and natural construction of Lin D, advocated by RTI, achieves that objective. Mur's construction, on the other hand, as favoured by Mr. Justice Jacobs, frustrates it. It achieves a result which we respectfully submit is contrary to common sense. And applying an iterative process to construction, it is clear that RTI's construction is that which should be preferred, and that the Tribunal of Fact should be left to assess what conduct on the facts is required by an obligation to use reasonable endeavours to overcome a force majeure event, without a legal straitjacket as to what can and cannot qualify as reasonable endeavours. I'd now just like to look briefly at 36.2, which is on page 121 of the award. .2 says, following the end of the force majeure event, the parties shall consult in good faith to make such adjustments as may be appropriate to the shipment schedule under this charter party. The judge attached minimal weight to 36.2 when reaching his overall conclusion, and we can see that from paragraph 107 of his judgment. But he considered that it did provide some marginal support for his view on the meaning of reasonable endeavours. Our submission is that far from supporting his view, 36.2 detracts from it, because it shows that the parties contemplated and required good faith efforts to be taken to minimise the effects of the force majeure event after it had ceased. And when you read that consistently with the rest of Clause 36, including 36.3d, it supports the fact that the parties were trying to fashion a force majeure clause that was grounded in the requirement to exercise reasonable efforts to overcome the effect of a force majeure event, whether it's during the currency of that event or after it finishes. So our conclusion on construction, applying those principles that I've endeavoured to outline, is that you should adopt RTI's broad case, or at the very least adopt its narrower alternative case, which is limited to the currency of payment, and to find that reasonable endeavours were not exercised by Mur in this case, based upon the findings of fact made by the tribunal. I'd now like to turn, if I may, to the Bullman and Fenwick case and the Vancouver strikes cases. Now, we've dealt with these cases at some length in our skeleton, and the facts will be well known to the court, and I would be most grateful if paragraphs 33 to 52 could be adopted as part of our oral submissions. And I would like to make the following 7 key points by way of summary in relation to how we say you should treat Bullman and Vancouver strikes. The first point is that neither Bullman nor Vancouver strikes concerned a force majeure clause. The second point is that unlike the case with which this appeal is concerned, neither Bullman nor Vancouver strikes concerned a specially negotiated reasonable endeavours clause, analogous to 36.3d. And just by way of recap, the principles of construction set out in our paragraph 10e of our skeleton and at Chitty, section 26062 are important. It isn't a legitimate approach to construction of a reasonable endeavours clause to do so by reference to other authorities. The judge has fallen into that trap, and he has fashioned a principle of apparently universal application from Bullman and Vancouver strikes, notwithstanding that those cases didn't concern a force majeure clause, did not have the reasonable endeavours clause specially negotiated as an express term, and which concern very different facts, and concern as they do the interpretation of a strikes exception clause, not a force majeure clause. The third point is that unlike the instant case, neither Bullman nor Vancouver strikes involved a dispute centering on whether there was an obligation to accept a non-contractual currency.
Sorry, can you just say that again?
Yes. Neither Bullman nor Vancouver strikes involved a dispute centering on whether there was an obligation to accept a non-contractual currency as part of reasonable endeavours. Had nothing to do with currency at all. The fourth point is that the arguments in Bullman and Vancouver strikes were, as is to be expected, quite different to those that are relevant to the present case. Bullman and Vancouver strikes were concerned with construing an option and were clearly influenced by the important consideration that it would be very difficult to prove that selecting an alternative discharge port, those are the facts of Bullman, or an alternative cargo, which were the facts of Vancouver strikes, was reasonable. And that is because of the facts as they emerge from the judgments in both of those authorities, it wouldn't have made any difference to the quantum of demurrage being claimed by the ship owners. I can make that good if we go to Bullman at tab 1 of the authorities. We can see that the decision at first instance begins at page 2 of the manual, down Pollock, and just over halfway down we can see terms of the Charter Party set out. Proceed to London, either to the Pool, Regent's Canal, Victoria Docks, the Derrick's, Beckton, or Safe Berth as ordered, ... But the jury found, you note those words, the jury found that the defendants could not by any diligence on their part have improved the situation either by taking the ship to another place or by using any reasonable efforts to obtain labourers to discharge her at the Regent's Canal.
Just to be clear, I think I read that as meaning once it had got to the Regent's Canal, that was the position. Is that a correct understanding or a wrong understanding?
I've read that as a finding by the jury that they were not of the view that the position could have been improved by taking the ship to another place.
But how is that reconcilable with the jury's finding that they ought reasonably to have intercepted the vessel and taken it somewhere where there wasn't a strike? Because if they'd taken it somewhere where there wasn't a strike, presumably there wouldn't have been a problem.
Well, that's the issue on the facts. One simply doesn't know whether there would have been the same problem in terms of delay somewhere else.
But do we not know that from 181?
Well,
I therefore asked the jury whether it being reasonable, as they had found to order the ship to the Regent's Canal, it was reasonable to allow
it was reasonable to order the vessel there originally, but it was not reasonable to allow her to continue her course. But I had read page 180 and the sentence that I had directed you to as suggesting that it would not in fact have made any difference in terms of the delay to which the vessel would have been subject, and it would obviously have been on the party that was relying upon the exception to prove that it would have made a difference. But in any event, as far as one can see, it's not...
Doesn't the next sentence go on to say that the jury found that if the vessel had been stopped at Gravesend and ordered to some other place of discharge, she could have been discharged within the allowed period?
I'm sorry, where is my lord looking?
Just immediately above the red sidelining.
If the vessel had been stopped at Gravesend and ordered to some other place of discharge named in the Charter, she could have been discharged within the period allowed by the Charter Party, but if she'd not stopped at Gravesend and was once allowed to go to Regent's Canal, she couldn't have been so discharged within time. Therefore, that raises the question whether it was in the right of the defendants on the true construction to order her to Regent's Canal and leave that order undisturbed. And then the real question identified, just over halfway down on page 4, turns on the real rights of the parties under the Charter Party and not on the question of whether it was reasonable or unreasonable to send the vessel to Regent's Canal. So, my lord is absolutely right.
But on the facts, it would have made a difference.
On the facts, it would have made a difference. And the point that I'm making about the facts is probably more apposite to Vancouver strikes, where it's clear that they do make findings it wouldn't have made a difference. And my lord is quite right, and I'm grateful for pointing out that point on page 3 of the judgment. However, one can see that the argument in Bullman did not concern an analysis of what reasonable endeavours would have entailed in the context of an obligation such as we are concerned with here. The Vancouver Strikes case, which is at tab 5 in the Court of Appeal, also supports the proposition that there was some doubt about whether it was reasonable on the facts and whether it would have made any difference to the amount of demurrage claimed. If one goes to the judgment, starting at page 197 of your bundle, you can see in the decision of Lord Justice Wilmer, who in fact dissented on the point of construction, but was followed by the other members of the court on the facts, says this at the top of page 197, is that the Charterists to bring themselves within their exception clause if they can. This being so, I entertain no doubt, notwithstanding Charterers' argument to the contrary, that the judge rightly held the burden of proof to be on them to show that if they'd attempted to load alternative cargoes, allowing a reasonable time for the changeover, the delay would have been no less. These facts must be looked at, in my judgment, not as they are now known ex post facto to have turned out, but as they would have appeared to a reasonable charterer making all reasonable inquiries at the time when the decision fell to be made. If the charterers can show that in the light of the facts then known it was reasonable to take the view that no delay would have been saved if they'd attempted to load alternative cargoes, then I think they would sufficiently discharge the onus upon them. The facts with regard to availability of flour have been set out. It's clear that there would have been considerable delay in obtaining the necessary quantity. And then, skipping a few lines, if the requirements of all these ships were taken into account, it must be obvious, or at least it must reasonably have appeared obvious at the time, that an immensely long delay, measurable in months rather than weeks or days, would be bound to elapse before they could all be loaded with the necessary quantity of flour. Facts with regards to barley are not so clear. Judge found that no barley was in fact available for the Ministry of Food. Then if we go over the page, third line, but the real difficulty about loading barley was that being a bulk cargo, it could only be loaded through one of the two elevators not on strike. It was therefore subject to the same bottleneck as bulk wheat. And it seems inconceivable, having regard to Smith's decision to use the available elevators for the loading of parcels of wheat into liners, that permission could have been obtained for using the same elevators for the purpose of loading barley into tanks. In the circumstances, I think the judge cannot be criticised in his finding that for practical purposes, barley wasn't an available cargo. They then considered flour, which applied to the Riverton, and he says it remains to my mind extremely doubtful whether any of the other ships, even if they had loaded part cargoes of flour and or barley, would in the end of it all have been any better off. And then the final paragraph on 198, any course which charterers could have taken by way of loading alternative parcels of cargo would in any case have involved the ships in considerable delay. And then the conclusion on 199, fifth line down. In these circumstances, my conclusion is that the ship owner's contention fails on the facts. And by the time the case gets to the House of Lords, the only live question relevant for present purposes concerned the right of the charterer to adhere to his preferred cargo. So this brings me to my fifth point, which is that there is nothing in either Bullman or Vancouver strikes which assists on the central question in this appeal, which is whether a reasonable endeavours clause, as we have here, requires a party affected by a force majeure event to accept non-contractual performance of a currency obligation, which as a matter of fact has been found to have been reasonable and to cause no detriment to the receiving party. The sixth point, which I'd like to make arising from Bullman and Vancouver strikes, is this. My learned friend's arguments on those two cases, they contain what we say is an impermissible leap from the proposition that a party with a contractual option has no obligation to exercise that option, reasonably or at all, to the proposition that as a matter of law, reasonable endeavours, in the express definition of a force majeure event, can never include acceptance of non-contractual performance. Even if you're with Mur and hold that they had an unfettered right to refuse euros, it doesn't follow from this that it could satisfy the definition of a force majeure event in clause 36 if it did refuse euros in circumstances where it was unreasonable. And there's nothing in Bullman or Vancouver strikes which militates against that conclusion. So the final point that we make, 7, is that these cases do not assist you at all in determining what is the simple question, which is whether the force majeure event in the present case could have been overcome by reasonable endeavours. And these cases provide no justification for importing a gloss on the meaning of reasonable endeavours, and no justification for disapplying ordinary principles of construction to this clause, which should lead to RTI's argument, either the broad argument or the narrow argument succeeding. I'd now like to go...
You've made the point from time to time there's no case or academic writing which says that a clause like this is limited to contractual performance. Can we turn it round and ask the question, is there anything, any case which shows a clause like this being applied to non-contractual performance?
This is Mur's argument, and we fully accept that there is no clear statement of principle that deals with the matter either way. However, that isn't surprising, because if parties act reasonably, why will a matter come to arbitration? Why will a matter come to court? If they act reasonably in accepting non-contractual performance, there isn't a dispute. So why would you expect there to be cases that would illustrate that principle? And a further point arises in relation to mitigation, which is considered to be the correct way to argue by analogy with what is required by reasonable endeavours. And I was about to come on to mitigation as an apposite analogy. Because when you look at mitigation, it's quite clear that there is no bright line in relation to mitigation that says, oh, a party, to act unreasonably has to be factoring into that the fact that it has to accept only contractual performance. There's no such bright line. And the authorities, such as they are...
Well, if mitigation were limited to contractual performance, there'd be no question of any damages to consider.
Exactly. But, I mean, if you're looking at whether mitigation is an appropriate analogy, as we say it is, then you are looking at a whole factual range of circumstances, including whether the party in breach is offering you different terms from what were in the contract as a means of limiting loss. Now, the learned judge, in his judgment at para 117, regarded principles of mitigation as not particularly helpful because they were only derived in the context of damages investigations. But we consider that principles of mitigation are relevant to the steps that should reasonably be taken to minimise the effects of a breach of contract, just in the same way as what a reasonable endeavours provision in a force majeure clause should have as its objective. They both have a similar objective. They concern steps that should reasonably be taken to minimise the effects of an event. One is a breach of contract, the other is a force majeure event. Both of them disrupt the contract. Both principles require the party affected to act reasonably. And there are no artificial limits on what conduct may or may not amount to an unreasonable failure to mitigate the effects of a breach of contract. It's all a question of fact for the trier of fact in the light of all the relevant circumstances. Now that's apparent from PAYZU, which is in tab 2 of the Court's Authorities Bundle. And we've dealt with the facts of PAYZU in our skeleton at paragraph 63. So in PAYZU, sellers had offered to deliver goods only if they received cash at the time of order, and that was a breach of contract. And it was held that the buyer, acting reasonably, should have mitigated by accepting the seller's offer. And the case is important because it confirms that steps taken in mitigation are questions of fact and not law. That can be seen in the last part of the head note on page 8. Court of Appeal, a question of what steps a plaintiff in an action for breach of contract should take towards mitigating the damage is a question of fact and not law. Court below come to a proper conclusion. And then we have the judgment itself, 588 of the text, 15 of your bundle. Having quoted from British Westinghouse, Lord Haldane said, the fundamental basis is thus compensation for pecuniary loss naturally flowing from breach, but this first principle is qualified by a second, which imposes on a plaintiff the duty of taking all reasonable steps to mitigate loss consequent on a breach, and debars him from claiming any part of the damage which is due to his neglect to take such steps. And then, skipping a few lines, it is plain that the question of what is reasonable to do in mitigation of his damage cannot be a question of law, but must be one of fact in the circumstances of each particular case. And then the sentence above that, the person who has broken the contract not being exposed to additional cost by reason of the plaintiff not doing what they ought to have done as reasonable men, and the plaintiffs not being under any obligation to do anything otherwise than in the ordinary course of business. We say the same position should prevail when considering the content of the reasonable endeavours obligation in 36(3)(d), and that this is the approach that the tribunal took correctly, and it's only because of the error respectfully made by the learned judge below that there is a qualification which has been introduced into the natural and ordinary meaning of reasonable endeavours. If you go to tab 35 of your authorities bundles, my lord, you will see a leading text on offshore construction law. Which has a section entitled Force Majeure. This is Offshore Construction Law and Practice, 2nd edition, 2021. And
I'm sure Lord Justice Mayles knows, but who are the authors of this? Oh, I see at the bottom, do I?
Yes, I think it's yes. Stuart Beadnell and Simon Moore.
Yep.
And the duty of mitigation is being discussed in the context of force majeure. And you'll remember the Canadian authority, which also uses the mitigation analogy at tab 15. So at 1554, the authors say this: it is normal in force majeure clauses for the contractor's entitlement to a postponement of the delivery date to be made expressly subject to an obligation to take reasonable steps or to exercise due diligence to avoid or reduce the delay caused by the force majeure event. And then there's a footnote that refers to the B&S contracts case at tab 12, which is more fully discussed in Lewison, which you may wish to look at in due course. It's tab 30, page 745 at paragraph 1325. I won't take up time with that now, but continuing with this textbook, stipulating that the postponement of the delivery date should be limited only to the extent of the delay that may not be avoided by the exercise of such due diligence or reasonable endeavours. Or, 2, making the requirement to take such mitigating measures a condition of the contractor's entitlement to a postponement of the delivery date. Then if one skips down to 1557, what precisely is the contractor obliged to achieve in order to discharge the obligation of due diligence or to exercise reasonable endeavours or to undertake a duty of mitigating the effects of force majeure? Are there precise obligations that arise in each case, depending on the expression used, and is each one materially different from the other? Under English law, the precise obligations that arise from particular expressions will depend, as usual, on the context in which such expressions are used. This may seem an unhelpful rule of interpretation, but the corollary is that expressions do not, as a matter of English law, carry fixed meanings. Thus, it cannot be said with any certainty that an obligation to exercise due diligence in the context of an offshore construction project carries any greater obligation than the obligation to use reasonable endeavours or the duty of mitigation. And then 1558, the crucial point is that the contractor is not obliged, without clear words to that effect, to perform its mitigating efforts in a manner materially different from the method contemplated by the contract for performance of the work. And then 1559, however, in assessing whether the contractor has undertaken sufficient mitigating efforts, the question is a factual one. And then the footnote refers to Heizu. And then 1560 over the page, under English law, the contractor will not be penalised for not using methods or taking measures which would be unusually difficult or troublesome. The imposition of an obligation to take more measures would therefore require clear words, etc. And then there's a reference to the B&S contractors case in footnote 27. The fact that the author of this textbook discusses force majeure and steps taken to overcome force majeure events in the context of a heading, duty of mitigation, is quite powerful, that that's how people in the industry regard it. And we respectfully submit the judge was wrong to reject as a helpful analogy the principles applicable to mitigation.
Does this not bring us back to the question asked by my Lord Justice Males earlier, which is who is the party affected? So your answer to that question was Mur.
Yes.
And I understand why you say that, but even so, it seems a bit odd, because one might have thought that the party affected was RTI, because the effect of the expert evidence was that RTI's payment in US dollars was going to be held up in the US banking system for a period of time. And what one might say, well, therefore, the party affected is RTI. RTI needs to exercise reasonable endeavours. And your argument is, well, we did that because we offered to pay in euros instead. But then that then leads on to the question of, well, where is the obligation on Mur, if you view it in that way, to accept the non-contractual performance?
Well, my lord, the issue arises like this. I mean, a force majeure notice was not served by RTI. It was served by Mur. And service of a notice is a precondition to the right to rely upon force majeure. So it's Mur that need to show that they come within all limbs of 36.1 to 3. And if they are invoking force majeure, they assume the burden of showing that they are the party affected. And so that is why the reasonable endeavours apply to them.
And the arbitrators have found, if one's looking at it from that perspective, that they are affected in the sense that it reasonably impedes their ability to discharge or load, because they can't be expected to discharge or load if they're not being paid. So it has been found. And yet, when one comes to the question of how you overcome that, why is not one looking at what RTI can do, given that it's RTI's performance that is, as it were, the source of the problem?
Well, RTI have done all they can. They want to pay dollars, but Mur is saying that's not allowed. They're offering euros in a commercially equivalent amount, together with exchange rate losses and costs, but that's been rejected. So RTI can't do anything more. RTI, if it is a relevant person affected by 36(3)D, can't do any more than it's already done. And there was never a suggestion that RTI had acted unreasonably at any stage in relation to this. The relevant inquiry is whether Mur acted with reasonable endeavours, and whether the tribunal's finding in paragraph 50 and 51 that they failed to use reasonable endeavours, and for that reason failed to be able to take advantage of the first force majeure clause, is liable to be overturned because of this so-called principle of law that reasonable endeavours can never include acceptance of non-contractual performance. So when you're looking at the way in which the argument has arisen, the fact that it's Mur that served the force majeure notice, the fact that it's Mur that needs to bring itself within the limbs of that clause, the relevant finding of fact is that made by the tribunal, which is that Mur did not behave reasonably because they were offered the commercial equivalent. With no detriment to them, they could have accepted it, and there would have been no trouble with resuming nominations and loading and discharging.
As it this is doubtless caricature, but caricaturing it in this way, as it turns out, although Mur complained that it would not be lawful to pay in dollars, actually the basis for the force majeure was not an inability to perform a contractual obligation. It complained that although you could perform your contractual obligation, that wasn't good enough. And you then attempted to address that complaint. Does that make a difference? Does it make a difference that what is in the event being complained of is not an inability to perform a contract, but the fact that performing the contract wouldn't be good enough?
Well, it doesn't make a difference to the tribunal's finding of fact, which is that Mur, in the circumstances of the case, in the light of all the factors that they considered, did not behave reasonably or with reasonable endeavours. That conclusion of fact is sacrosanct, and the nuance that you just put to me doesn't justify a gloss on what reasonable endeavours means. It still means what it has as its ordinary and natural meaning, which is the same as it does in the context of mitigation.
But I just wonder whether there might not be a point that helps you here in the sense.
Well, I don't want to reject that out of hand.
If they're saying, well, contractual performance isn't good enough, it isn't so obviously inapposite for you to say, well, look, if you're not satisfied with contractual performance, we'll give you this as an alternative.
Yeah. Well, my lord, yes, that shows how doubly unreasonable Mur's conduct is, and why Mur cannot now turn around and complain about non-contractual performance when they could quite easily have agreed to accept US dollars, which were not a prohibited currency, and accept that there would have been some delay inherent in the loading. But instead what they were looking to do was to throw up the COA, and we can see that from the message we looked at. And they took the unreasonable stance of rejecting euros plus all the costs and expenses. And I'm sure the tribunal were able to see through that very clearly, which is why they made the finding of fact they did. So just tying up the threads on mitigation, we submit the judge was wrong to reject as a helpful analogy principles applicable to mitigation, and he should have used those principles to assist him in informing his construction of what is required by reasonable endeavours in the present case, which is it's all a matter of fact, looking at all the evidence, and that's for the tribunal to determine. And I made the point already, but I'll just give it to you for your note. It is of interest to note that the mitigation analogy is adopted by the appellate courts in Canada. The at-call continental energy case, which we looked at briefly in tab 14, that concerned a force majeure clause in clause 9a, set out in paragraph 29 of the judgment. And the court considered that this clause imposed a duty to mitigate, paragraphs 28 and 30. And when you're looking at policy and whether people are going to say, oh, English law will be too uncertain if you leave these things to the triers of fact, it is important to have regard to the fact that mitigation is already known to be within the sole province of the trier of fact, and that authorities in Canada, and as we'll see in New York also, adopt a very similar approach. So, my lords, if I can now turn to consider the Suez cases, which we deal with in paragraphs 64 and following of our skeleton. And the propositions are really as follows. When you consider the scope of a force majeure clause, the court should take account of the common law doctrine of frustration, because this forms part of the legal backdrop against which such clauses are framed. And if you need a reference for that, it's Lewison at tab 28, page 728 of the bundle, at paragraph 4.34. And Lewison cites the Thames Valley Power case, which is at tab 15 of the bundle, in support of that.
Sorry, I wasn't keeping up. The Lewison reference was which tab?
It's tab 28, my lord, at page 728 of the bundle, paragraph 4.34, which cites footnote 78, the Thames Valley Power case, in connection with the statement at the end of 434, which says this: similarly, considering the scope of a force majeure clause, the court will take into account the common law doctrine of frustration, which forms part of the legal backdrop against which such clauses are framed. And Thames Valley Power is at tab 15, for your note. And the relevant passage is paragraph 50, subparagraph 4. I think it was incorrectly referenced in our skeleton on page 395 of the report, where Mr. Justice Christopher Clark says, I accept, of course, that each clause must be considered on its own wording, and that force majeure clauses are not to be interpreted on the assumption that they are necessarily intended to express in words the common law doctrine of frustration. Nevertheless, this line of authority, the legal backdrop against which the relevant contract was written, strongly supports the proposition that this case is an exception. No case has been cited to me in which a clause such as the present has been interpreted as relieving the party from its obligation to perform, because performance of the contract has become economically more burdensome. So that the analogy with frustration was being deployed in that case for that purpose. Now, the Suez cases are frustration cases, and they are conveniently summarised and discussed in Peel at paragraph 4.111, which is at tab 32 of the authorities manual. And in fact, you may wish to read paragraph 4110 again, which talks about the history of the overruling of the Massalia by the Eugenia. And 4111 is important because it deals with a case where the Suez route forms part of the contractual route. And the cases that are discussed in this section show that the fact that a contractual route becomes impossible to perform because in this case the closure of the Suez Canal, does not invariably result in the discharge of the contract. And as the learned author states at the end of paragraph 4111 on page 758 of your bundle, thus even the failure of an expressly or impliedly stipulated method of performance will not discharge a contract if that method is not of fundamental importance, unless the parties make it clear that they intend the stipulated method to be exclusive. And in 4112, the voyage charter cases show that it's very difficult for the closure of a contemplated or even of a specified route to discharge a contract of carriage so long as another practicable or more expensive route is available. So this line of authority shows that there is no bright line requiring continued performance of a contract in accordance with its strict terms in order to avoid discharge, or we would say suspension, because of the analogy between the two doctrines. Just as the court can consider whether the non-contractual method of performance is sufficiently fundamental to discharge a contract under the doctrine of frustration, so can the court, in the context of force majeure, consider whether the non-contractual method of performance in issue is sufficiently fundamental to entitle a party faced with a force majeure event to reject it, acting reasonably. Now, in practical terms, the decision of Mr. Justice Jacobs was to vindicate a total suspension of the COA while currency restrictions remained in place. And that would have included beyond the date when GL14 was issued in April 2018 and when Mur in fact resumed nominating ships. The only effect GL14 had, as we can see from the findings in the award that we looked at before, was to extend the latest date for wind down. It didn't have any other effects. So if the judge was right, and if Mur was entitled to continue to refuse euros, and in fact, fortunately, it did not continue to refuse euros, as the tribunal has found in paragraph 15, the result achieved would be equivalent to frustration, because there would have been no compulsion on Mur to do anything other than simply stubbornly refuse to accept euros until the COA duration ran out. And that's equivalent to frustration, in effect, in practical effect. Now that is a sufficiently surprising conclusion that it strongly suggests that the judge's interpretation of this force majeure clause is in error, because it produces a total suspension of future performance of the COA in circumstances where it's highly doubtful that any court would treat the COA as frustrated in the same circumstances. I mean, can one imagine a frustration plea being based upon a restriction in a currency and a refusal of the recipient of the payment to accept the commercial equivalent as giving rise to frustration? Of course it would not, because there is no fundamental change to the obligations to be performed. And it's those considerations that lead us to submit that the Suez cases and the frustration doctrine, which always informs the construction of a force majeure clause, is instructive, and it demonstrates why the judge was wrong to reach the conclusion that he did, because it would give that force majeure clause the effect of frustration if Mur had continued its conduct after GL14 came into force. My Lords, I've got policy considerations to deal with, and then why the appeal should be allowed. And with a fair wind, I may in fact get to that by the break, if that suits you.
So much the better.
So in terms of policy considerations, the learned judge suggested in his judgment at paragraphs 112 and again in 131 that Mur's construction is to be preferred because it promotes certainty. with respect, the bright line proposed by Mur and adopted by the judge does involve a rewriting of the bargain that the parties made. And there is no warrant for concern that parties are going to hesitate before agreeing English law if this court concludes that the trier of fact has the sole province to decide what amounts to reasonable endeavours in any given case, including acceptance of non-contractual currency on commercially equivalent terms as were offered in this case. Now, the position in the USA is instructive, and we've dealt with this in our skeleton at paragraphs 71 to 74. There is a uniform commercial code which is extracted at tab 10 of your authorities bundle, which contains a section 2-614 at page 302 of your bundle, embodying a principle of commercial equivalent performance. And subparagraph 2, well, let me read one first of all. Where without fault of either party the agreed berthing, loading or unloading facilities fail, or an agreed type of carrier becomes unavailable, or the agreed manner of delivery otherwise becomes commercially impracticable, but a commercially reasonable substitute is available, such substitute performance must be tendered and accepted. 2. If the agreed means or manner of payment fails because of domestic or foreign governmental regulation, the seller may withhold or stop delivery unless the buyer provides a means or manner of payment which is commercially a substantial equivalent. ... Now that principle of commercial equivalence has been applied both in court and in arbitrations governed by New York law. There was an SMA arbitration in New York which we cited to the judge, and he doesn't think it's of any assistance because it is New York law. But as we say in paragraph 72 of our skeleton, it concerned an unsuccessful submission by the party in that case, Ferramina, that it was excused by impossibility from an obligation to make payment in dollars. Now, if we can go to tab 16, where the award is to be found, I can take you straight to the relevant passage. There were a number of claims and cross-claims, but if you look at just below the second whole patch on 410, we're dealing here with a currency conversion claim, and the court says this, the tribunal says this: the fact that performance could not be made in the exact manner called for by the contract does not excuse performance if a commercially reasonable alternative is available that will give the parties the benefit of their bargain. And then there's the citation of the United Equities case, which is at tab 9 of the bundle, and which the court has. And it is a case in the Supreme Court Appellate Division, First Department of New York. And applying the same principle of reasonable commercial substitute, they held that there was no ground for invoking frustration of expectations or force majeure. The head note of paragraph 6 cites the Uniform Commercial Code, paragraph 2-6141. The fact that other courts recognise explicitly commercially reasonable substitutes in the context of disputes such as that which arises in the present case is a relevant consideration to bear in mind. Does English law want to be out on a limb on the basis that parties will prefer to agree English law if it has a straitjacket and has bright lines, even where the parties would prefer the trier of fact to decide issues of fact? we submit that as a matter of policy, there's every reason why English law should not be regarded as preventing commercial judges and arbitrators from finding in appropriate cases that reasonable endeavours can entail the acceptance of non-contractual performance, particularly whereas here on the findings of fact made by the tribunal, in particular at paragraph 50 of their award, the tender of euros and the agreement to bear all associated losses and expenses was commercially equivalent performance. And then finally, my lords, why the appeal should be allowed. And we're going to make 4 points. The question on this appeal is whether an event can be a force majeure event within the meaning of clause 36.3, even though the party affected by it could easily overcome its effects by accepting a non-contractual currency with no detriment to them in financial terms. That is an unappealable finding of fact. That's our point 1. Point 2, if you conclude that there was no obligation on Mur to accept euros on the no detriment terms offered by RTI, then Mur can effectively suspend all further performance of the COA, an outcome equivalent to frustration, which certainly cannot have been intended. Third point is, this result is not warranted as a matter of construction and offends, in my respectful submission, commercial common sense. And the fourth point is that the principle formulated by Mur, whereby reasonable endeavours can never include acceptance of a reasonable but non-contractual currency of payment, is highly undesirable in principle and as a matter of policy. What is needed is a pragmatic judgment by the trier of fact as to what reasonable endeavours requires on the facts of any given case. That is what our tribunal has done, and its award ought to be restored and RTI's appeal therefore allowed.
That's very well timed. So we'll stop there, and Mr. Easton, over to you after lunch.
Thank you.
All rise.